All right, good afternoon, everyone. It is 2 o'clock by my watch, so we're going to get started here. Thank you for joining us for our November CLE. The topic this month is rent escrow, both from an attorney's and a organized perspective. We're joined by Samuel Spade, Homeline's litigation director and staff attorney, and Reagan Reek, one of our organizers. So just as some quick housekeeping here, what is Homeline? We are a legal nonprofit, and we provide legal advice to tenants across the state of Minnesota, regardless of income. You can see our phone number there, and we operate in 4 languages: English, Spanish, Somali, and Hmong. And you can see the phone numbers for each hotline there, as well as online. You can reach us by email at homelinemn.org/email to fill out the intake form. This session today is being recorded and will be available on our website within a few days. If you have any questions, please use the Q&A function rather than the chat at the bottom of your screen to submit your questions. And if you're an attorney, we will be applying for 1.5 standard CLE credits after this session. And with that, Samuel, floor is yours.
All right. Well, as Philip said, my name is Samuel Spade. I've worked at Homeline now for about 15 years. I'm Homeline's Impact Litigation and Research Director, and I'm going to be talking about mostly the legal and the sort of nuts and bolts of the rent escrow action. Next slide. So first, I want to start with a little bit of background and talk briefly about why rent escrows exist. They've existed now for over 20 years, I think maybe even close to 30 at this point. And historically, the problem that they're trying to solve is repairs. That's the primary purpose of a rent escrow. It's not the only thing that a rent escrow can do now, especially, but that is the primary purpose of a rent escrow, is a tenant trying to get repairs. And the reason they exist is because when they were created, really the only other option was the tenant remedies action, which I've got there on the slide. And that was just not really accessible for tenants. You kind of needed to be an attorney to do that. So rent escrows are not just trying to help tenants solve repairs, but they're trying to help tenants get repairs for their property by themselves without representation. That's sort of the goal of a rent escrow. However, tenants can be represented and often are represented. And we're going to talk about rent escrows, but just briefly, I do want to say that there are other options for forcing repairs. You can withhold rent. That is legal in Minnesota for a tenant to withhold rent. Not something we normally advise, but it is possible. There's also an emergency tenant remedies action, which can be used for emergency repairs. And that can be done even if you are not an attorney, though, again, having an attorney is super helpful. And there is the tenant remedies action, which still exists and does give some slightly broader scope to a few things, but you do kind of have to be an attorney or need an attorney to go through the tenant remedies action. It's not really accessible to people who don't have legal training. I'm not saying it's impossible. It's just it's kind of like district court at that point. Not exactly, but kind of, and so it's a lot harder. So rent escrows exist primarily to help tenants get repairs, especially to do so without necessarily being directly represented by an attorney, but they are now much broader and they cover a lot more, and we'll talk about that as we go. Next slide. So what are rent escrows? It probably is obvious by this point, but they are a court case. They're a court case filed by a residential tenant, specifically by a residential tenant, for a violation of 504B.001 subdivision 14, tried to the court. This is important. There's no right to a jury trial in a rent escrow. It is tried specifically to the court, to a judge in Hennepin and Ramsey County, and some other counties, maybe to a referee, where you have a right to judge review, but it's tried to the court, not to a jury. The primary remedy is repairs, but this is not the only remedy. There are many other remedies that the court can provide. Most commonly, you have things like rent abatement. So this is a reduction of rent going backwards, or rent abatement going forwards, a reduction of rent going forwards by a percentage or sometimes just a full amount. And the court has discretion to go even beyond that. So you see a lot of lease terminations is probably the third most common thing. You see judges ordering landlords to pay for like hotel bills or lost personal property or things like that in some cases as well. So there's a broad selection of remedies, and this is actually, well, I'll get to that in a later slide. Next slide. So let's start at the beginning. What can you file a rent escrow for? This is defined by Minnesota Statute 504B.001, subdivision 14. There are 5 bullet points in this subdivision, and they are, very broadly speaking, any code violation. So this is mostly going to be from the city, but it sometimes is from the state or a county inspector. But generally, you're talking about city code violations. The city inspector comes out and cites the landlord, something like that. A violation of anything in Chapter 504B. This is one of the significant expansions that happened this year, I believe, if I have my notes correct. And so it is very recent. This is something that was not true until, again, just a few months ago. Now, anything in Chapter 504B, which is the primary chapter that covers, say 80 to 90% of landlord-tenant law, if there is a violation of that, the tenant can bring it in front of a judge by filing a rent escrow. So when I say rent escrows are no longer for repairs, this is part of what I mean is if it's in Chapter 504B, which covers things like privacy, which you could already file a rent escrow for, repairs, which you could already file a rent escrow for, but also things like prohibited fees, retaliation, and other things like that, you can now file a rent escrow for. Also, discrimination has been added. You can file a rent escrow for discrimination. Whether or not this is a good idea, I think is a very open question. Again, this is very new. I am not aware of any court cases for this. You don't get a jury trial, as I said, with a rent escrow. You might want a jury trial for discrimination. You do get discovery with the rent escrow, but it is kind of limited. These are hurry up cases. The court has broad discretion on remedies, but they are discretionary, which I'll talk about a bit later. But discretionary means that some things you might be able to get if you went to district court or something like that, you can't guarantee in a rent escrow. So this is a nice expansion for tenants and something that a tenant might be able to use as a tool to pursue certain types of discriminatory actions, but it does have to be considered carefully because rent escrows are still fairly fast court cases. They don't have all of the things that you might want for certain types of violations, especially more serious violations. You can also file a rent escrow for violations of subsidized housing law. This was also one of the ones that was added this year. And so, again, I'm not really actually aware of any court cases that have used this yet. They might exist out there, but unless you're part of a district court case, you don't really hear about it until it makes its way through the Court of Appeals process. And those just haven't had time to happen yet. And kind of like with discrimination, there are other ways to pursue a lot of subsidizing housing law violations. The rent escrow may or may not be the right choice, but it is nice that it's available. And then finally, violations of the lease. This has been around for a long time. Tenants can file a rent escrow to enforce the lease. And this is actually very useful because otherwise, the way you enforce a contract breach would be maybe through district court. Again, not really accessible to most people unless you are an attorney or are represented by an attorney. So the fact that you can get your lease or your contract question about your lease in front of a judge very quickly, actually, is very nice. And this has been used by a number of tenants for years because this has been part of the statute for a while. Next slide. So those are the reasons that you can file an eviction. Before you file an eviction, there's a couple things that you have to do. And the first is you have to have an expired inspector's report or a 14-day letter. So an expired inspector's report, the tenant calls the city, says, hey, I want an inspection. The city comes out, does an inspection of the property, says, landlord, you've got to fix X, Y, and Z. You have 30 days. Landlord doesn't fix it in 30 days, even if the city gives the landlord an extension, which is very common. Cities will almost always give the landlord an extension of 1 and maybe 2 months. Maybe they'll give 2 to 3 extensions. The first expired in inspector's report allows the tenant to file a rent escrow. And yes, I did mean to say rent escrow, not eviction. The first expired inspector's report allows the tenant to file a rent escrow, even if the city then gives another extension or something like that. The tenant can also give a 14-day letter and file a rent escrow if the landlord doesn't fix the issues within 14 days. In fact, this is a very good way for the tenant to cut down the city inspector's deadline. The city inspector comes out and says, landlord, fix everything in 30 days. The tenant writes a letter that says, landlord, fix everything in the city inspector's report, sends that letter to the landlord. Now the landlord has 14 days or the tenant can file uh, a rent escrow. Now, a tenant can also file a rent escrow and allege that the deadline given by the city inspector was too long. This is allowed. I don't really like it, and I've never used it because, frankly, again, you can cut the inspector's report down to 14 days by sending a letter. And if you want to file something faster than 14 days, you probably should be looking at something like an emergency tenant remedies action instead. You're basically saying, this is an emergency at this point. We can't even wait 14 days. So you're probably not trying to tell the court the inspector just gave too much time. You then file the affidavit of rent escrow. This is a court form. You could, in theory, write your own form if you're an attorney. I have filed, there was a point in time where I think I could say I filed more rent escrows than any other attorney. That is certainly no longer true. I never use anything but the court provided form. There is basically no reason to. Maybe if you work for legal aid and you file a lot of these and you have your own form for specific reasons, that's worthwhile. But I use the rent escrow form provided by the court. Tenants definitely, if they're not representing, or if they don't have someone representing themselves, should be advised to use the rent escrow form provided by the court. There's basically no reason to draft your own. The rent escrow form has some basic questions. They're all pretty easy to answer. One of the only complicated ones that can trip people up is the estimated cost of repairs. So the rent affidavit of rent escrow asks tenants or the attorney, if they're being represented by an attorney, to estimate the cost of repairs. And the court does this for one very specific reason. Under the rent escrow statute, which is 504B.385, the court will serve the paperwork on the landlord unless the amount the tenant is asking for exceeds the conciliation court limit. The conciliation court limit right now is $20,000. So basically, as long as the court thinks that the tenant is going to be asking for something less than 20,000, and the court sort of interprets, if the tenant is saying, I want to repair, and that repair costs $10,000, that's part of what the tenant is asking for. As long as the court thinks that the tenant is asking for something less than 20,000, the court will serve. And so that's why the court wants to know the estimated cost of repairs. If the tenant is saying, landlord, you've got to do this thing and it's going to cost $50,000, something like that, which is rare but does happen. Well, at that point, that's a lot of money. The court says, all right, tenant, you've got to go through the normal civil procedure process of serving the landlord. So what this question is really asking is, is this going to be over 20,000? In most cases, the number is just so much lower than this that like a basic calculation or guess is going to be fine. If it looks like it might be close, say the tenant is asking for some pretty serious repairs, then I think, especially as an attorney, you want to do your due diligence and do some actual estimations. I have called professionals who would do that type of work and got, not quotes in the sense that they came out and gave me a quote, but like a range, and gone with the higher range, something like that. And again, all that really happens here is if the tenant goes above 20,000, the court the court paperwork has to be served the way you would normally serve district court paperwork. You have to go through the standard process service, so personal service, substitute service, something like that. Finally, I shouldn't say finally, but the next important thing is there's a question about whether or not the tenant needs to escrow rent. The tenant does not need to escrow rent if no rent is owed. If a tenant is filing a rent escrow action and they are current on their rent, they don't have to escrow any rent. If they owe rent, they do have to escrow it. And this is actually an important thing because I talked at the start, most of these are filed for repairs. That's still true, even though it's been broadened significantly. So most of these are filed for repairs. A tenant can withhold rent because of repairs. We don't generally advise this, but if the tenant doesn't have the rent, so if they're $1,000, $2,000 behind, they cannot file a rent escrow unless they actually take that $2,000 and put it into escrow. Sometimes this is not possible because the tenant doesn't have the money. In that case, they may be forced into one of these other options, such as withholding rent and asserting a Fritz defense in an eviction case. However, if the tenant has the money and the rent has not been paid, the tenant pays the rent to the court. And there are actually some advantages to this, not legally speaking, but in practice, both anecdotally and several years ago, where we did a big survey of rent escrow cases. If the tenant has escrowed rent, the tenant is more likely to get rent back, both in settlements and by court order. Again, there's no legal reason for this. I think it's purely practical. If the court is holding on to a bunch of money, the court feels a little bit more comfortable saying 50% of this goes back to the tenant. And so when we're talking with tenants, we do try to advise them to time the rent escrow to a point where they would be paying rent into court. And that's actually a lot easier to do now that landlords have to give a 14-day notice before filing an eviction for non-payment, because technically the tenant can give a written notice on the first, and as long as they go and file on the 14th day, they can beat the landlord to filing the eviction. They can file the rent escrow before the landlord can give the 14-day notice and file the eviction for non-payment. It used to be the tenant really needed to like give the notice by the 15th of the month so that they could file immediately on the first. Still, this is better because the tenant then avoids arguments about late fees and those types of things. So it is still what we try to get tenants to do, but it's something to think about if you're a tenant or if you're advising a tenant on when to file a rent escrow. One thing that I really want to stress, and I think this is a big problem, frankly, for both tenants and attorneys, but don't be complicated or confusing. The court asks what issues there are. This should be a bullet point list. I see tenants, and I see tenants do this all the time. Unfortunately, they write out paragraphs, they attach additional pages saying, "Hey, these following things are wrong." This is not helpful. The court does not want to know that. The court will get into it at some point when they're actually having the trial, but in the actual rent escrow affidavit, it should be bullet points. If the tenant cannot say, the problems are a broken sink, leaking roof, broken window, the following things cited by the city inspector, anything beyond that is frankly too much. It should be that basic and straightforward. Maybe you get a little bit more for some of the more unusual things, like if you're filing for a privacy violation or you're filing for retaliation or something like that, you might need a couple extra words, but it really should be very short bullet point list without much additional detail in the affidavit. Finally, make sure that you are suing the right entity. This is a big deal. Again, for both attorneys and tenants. Attorneys, of course, probably more aware of it, but don't sue an individual if the individual is an employee or even the owner of a business and the business is the right person to sue. You can sue anyone who is a landlord, and under state law, landlords include both owner and management of the property, which means that you have, at least in most cases, two parties to sue. You have the owner and the management company. Generally, you want to list both. Maybe in some cases, the owner is so far removed that there's no reason to sue them, but you can, and sometimes it's still a good idea. Applies more pressure, bringing in the owner to the case. Last, ask for what you want. This is a big deal. There's a checkbox. There's a list of things that are sort of standard in an affidavit of rent escrow that you can ask a court for. But there's also a checkbox for other where you can write in what you want. This is where you write things like get out of the lease, compensation for other things beyond just pure rent abatement, and especially if you are filing one of these rent escrows for something that is a little bit beyond repairs, like enforcement of the lease. This is really where you do want to say specifically what you're looking for. Like, I want enforcement of this specific lease term. I want the landlord to retract this specific thing. I don't want the landlord to retaliate against me, something like that. Next slide. So at this point, we're going through the process chronologically. We know what a rent escrow is. We've talked about pre-filing and filing. So let's talk about the actual court process. Once you file the rent escrow, the initial hearing statutorily is supposed to be within 10 to 14 days. Now, just like you see with evictions, if the court is so busy that that is impossible, it may take longer than 14 days. And we do see that, especially in Hennepin and some other counties where there's a high volume of court cases. The court simply cannot meet this requirement, even though they're supposed to. They do really try, and I think that they do a pretty good job, but once in a while, it is longer than 14 days. It's seldom 10 days. Like, frankly, it is generally around that 14-day mark. That's the initial hearing. At this initial hearing, it does depend on the county and the judge, but generally almost nothing happens. What happens at the initial hearing normally is that the court tries to make sure that both parties are considering settlement, that they've mediated or tried to mediate the issue. And then if they haven't reached a deal, the court basically says, is there still a problem? Maybe they'll take a little bit, generally not even sworn testimony. They'll take a little bit of, back and forth from the tenant and landlord to try to figure out where things stand. Again, often like 5 minutes or less, maybe a little bit longer. And then they say, all right, if there isn't a resolution, not a clear resolution at this point, they'll schedule another hearing, and this will be, a trial or essentially an evidentiary hearing. Again, no right to a jury, so it'll be in front of a judge. This second hearing is where people will give evidence, present evidence, and sort of go through everything that actually happened. And generally, it happens within a week or two of the initial hearing. It does depend a bit on everyone's schedule, the courts included, but generally, again, happens within a week or two of the initial hearing. So you get the initial hearing, you get the second hearing. The second hearing generally fully resolves the issue. Not always, but generally rent escrows don't go beyond the second hearing. Uh, I say generally, I'm actually seeing this happen more and more where they do go beyond the second hearing. There's continuances or things like that. So maybe there's a shift, but let's say at least historically, a rent escrow will have two hearings. That initial hearing, which is pretty quick, pretty fast, and then that second hearing where there is actual evidence, testimony, that type of thing. And then the court will issue an order. There can be additional hearings. There can be continuances for hearings, evidentiary hearings, et cetera, but there also can be compliance hearings. So the court says, landlord, fix the following things within 1 month. We're going to set up a compliance hearing. Sometimes the court doesn't set up a compliance hearing. It just says, fix the following things within a month. And the landlord doesn't, so the tenant will make a motion and ask for a compliance hearing, and the court will grant it. So there can be additional hearings after the first few hearings to come back and sort of see what is happening. This is pretty rare. I don't see this very often. Generally, again, the court cases get resolved. The court orders the landlord to do the repairs. The landlord actually does it. But it does happen, and frankly, if it happens, that's when the court starts to get very harsh. There was a case that I was involved in many years ago now, where the court ordered the landlord to replace the carpet because of a water leak. The landlord did not do so. The court had a compliance hearing, and even though it was the carpet in the basement and like the basement was still kind of usable, the court was essentially so upset with the landlord for not doing it that they made rent zero going forward, and rent was just zero. And the landlord, for whatever reason, didn't fix the carpet for another like 6 or 7 months. And so the tenant had 6 or 7 months of free rent. Finally, they did fix the carpet, and they asked for a compliance hearing so they could get back in front of a judge and say that they did it. And, then they got rent set back up, et cetera. But if the tenant gets to compliance hearings, that's where the court often really starts sort of hammering the landlord with penalties, fines, et cetera. There are also actually fines in the statute, though I don't see those awarded very often. And the court has a lot of discretion, which we will talk about on the next slide. So the court has a bunch of discretion about what to do. Now, there are some sort of guidelines. The first guidelines or the first sort of judgment things that a court can do are found in 504B.385, subdivision 9. They can do things like order repairs. Again, most of these are filed for repairs. They can order repairs. They can include retroactive rent abatement. They can include prospective or future rent abatement. They can do a bunch of different things. But there is also, perhaps most importantly, another statute, 504B.425, that includes a bunch of additional things that the court can do. Most importantly, sort of a catch-all category that the um, court has discretion to sort of say, I don't want to say whatever they want because it is discretionary, so they can abuse the discretion, but they have a lot of leeway. And there's been a number of cases recently. Two of these are this year. One of them was last year, where landlords have been deciding to fight this discretionary issue. So I think all three of these cases were basically some form of significant rent abatement or um, paying for alternative spaces. That was the case in Castro v. Ferry and Murphy v. Aon. I don't actually remember Whitman v. Highland. Murphy v. Aon is published. Castro and Ferry and Whitman v. Highland are unpublished or non-presidential. But these are three very recent court cases where, again, landlords this blows my mind, actually. We were amicus in the Murphy v. Aon case, where the landlord was just saying the court doesn't have jurisdiction to order these things, like rent abatement, like the ordering the landlord to put the tenant up in a hotel, and it's just like. I did not understand what they were talking about. The Court of Appeals did not understand what they were talking about. I don't know what happened in the sort of landlord attorney community that they decided suddenly to fight a bunch of these things, but they lost all of them. And I think at this point, it's been pretty well established that the court has pretty broad discretion as to what to order in a judgment in a rent escrow case. Next question or next slide. Do we have any questions at this point? I do see a couple in the chat.
Yeah, we've
This is good.
Excuse me. Yeah, let's get through your slides and then we'll take a quick
Okay.
break to go through the questions we have.
So settlements. Obviously, one way the court case can end is by settlement. Rent escrows often force the landlord to consider settlements. We talk with tenants all the time. The tenants say things like, we want out of our lease. This is a very common, one of the most common reason tenants want to terminate their lease is due to unmade repairs. We want out of our lease. We want X, Y, Z. The landlord won't talk to us. The landlord will only agree to let us out of our lease if we pay, 2 months of additional rent as a fee, something like that. Landlords change their minds. They change their tune when they're forced into court. If they're corporations, again, depending a bit on where they are, which county, they're required to have an attorney. So they've got to go hire an attorney to represent themselves in court. And even if they are representing themselves, just going in front of a judge makes landlords a lot more willing to negotiate. So tenants have a lot of power to force settlements in these cases. And tenants who settle are more likely to receive a benefit beyond repairs. The most common benefit we see for settlements are things like rent abatement or lease termination, and lease termination is pretty high. Judges can terminate a lease, but that's up to the discretion of the court. So, when we're talking about the court's discretion, the positive side of this is that the court has discretion and can award the tenant almost anything that seems reasonable. But the flip side is that if they don't award a tenant something, it's very difficult to argue that they should have, because again, unless it was an absolute abuse of discretion, the tenant isn't going to be able to win that argument. The court has discretion, and courts don't often terminate a lease. They will, but it is less common. So if a tenant wants out of the lease, settlements in a rent escrow are the way to go. They're much more likely to get out of the lease by accepting a settlement or by forcing a settlement, maybe is a way to say it, than by going through the court process. If they go through the court process, the court, especially for repairs, probably going to order repairs. That's pretty common. I would say happens almost all the time. Might order some rent abatement. That's a little bit less common. And frankly, often the court doesn't award anything beyond those two things. Repairs and rent abatement, again, assuming the rent escrow is for repairs, court orders those two things, doesn't award anything else. So if the tenant is really looking for something that isn't repairs or rent abatement, settlement is probably the way to go. Next slide. Um, Sorry, is it still here or have we moved this slide?
Yeah, we moved that slide. That's
All
a
right.
mistake on my end.
So practice pointers. You know, I said this very briefly before, but tenants do normally win these. Courts order repairs, especially if it's about repairs. In most cases, we actually did a sort of a statistical analysis of this over a decade ago now. But we looked at over, I think, 200 rent escrows. Tenants won, I think, 70% of them, 70 to 80%. When there was a city inspector's order, they won basically 100%. I think the only ones they lost with the city inspector's order was where they made procedural defects, like they didn't do something that they needed to do. And they won, importantly, they won very often against attorneys. So unrepresented tenant against represented landlord. I don't remember the exact percentage. Probably should have looked it up. Maybe I will as we're going forward here. If anyone's curious, I can do that. But they still won over 50% of the cases, even when the tenant was unrepresented against a represented attorney. So these are, I don't want to say easy, but they're very doable cases for tenants to win if they have good evidence. And this is the main thing, is the tenant has to be going for an issue that they can easily document. So a repair that a tenant can photograph, one of the easiest things to win. City inspectors order repairs, or city inspectors that have ordered repairs, uh, like, again, nothing is guaranteed, but that's about as close as you get to a guarantee in one of these cases. A judge is simply not going to tell the landlord that they don't have to do what a city inspector said. So if the tenant has a city inspector's order, they are, again, so long as they don't make a procedural mistake, they're going to win that court case. Cases that tenants have more trouble winning are those where they don't have very good evidence. So these are, or where evidence is hard to collect. So these are things like neighbor disputes, where you're talking about noise, mold, or like cigarette smoke from some other neighbor or something like that, where you're talking about smells. Like, how do you prove noise or smells in a court? Like mold, you can prove if you can photograph it, but if you're just talking about something smelling moldy, that's very difficult unless you actually get an inspector to cite the landlord, or you get your own mold inspector to do air quality tests. And then you also bring that inspector to court to testify. So again, main practice pointer, tenants should have good evidence. Go for things where they've got good evidence. If they don't have evidence, that's where they start to lose. Sue the right entity. This is something that can be easy to mess up. You sue like an individual caretaker instead of the management company or the owner. Keep the affidavit of rent escrow simple. This is, I think, very important. Like, the court needs to know what the violation is. And there is, again, in like 99% of cases, no reason the violation can't be under 5 words. Like, it should be that simple. And if there are multiple violations, you have multiple lists, but generally pretty short. Keep it simple for the violations. Ask for what you want, like actually tell the court what you want, especially if you want something beyond repairs or rent abatement. Be prepared to settle. Again, especially if you want something beyond repairs or rent abatement, be prepared to settle. Make that the focus of the thing that you are negotiating for. And then finally, consider all of the costs of going to court. Reagan's going to talk about this a bit more when we get to her section. Um, but going to court is work. It is not, especially if the person is unrepresented, it's not their job. It's not something they know how to do necessarily. They've got to spend a lot of work, and they're spending this work, to get something that they should have gotten, of course. But that thing, you do have to balance it. For example, over the summer, you saw a rent escrow where the tenant sued because the laundry facilities were broken. They won. Again, tenants do generally win. And the court ordered the landlord to compensate the tenant for all of their use of the laundry facilities. So they had to go, excuse me, they had to go pay for to do laundry at a laundromat. And so the tenant won like $195 or something. And this is the right outcome. The tenant won. They got their filing fee back. They got the costs of their laundry, and that's good. And hopefully they were happy about it. But like they had to go through a court process, multiple court appearances to get $200. And for some people that is very much worth it. And for some people, that may not be worth it. And you're not going to get, obviously, attorneys are not going to get compensated necessarily, except maybe through attorney's fees for going to court. But if you're representing yourself, you don't get time off, or you don't get compensated for the time off going to court. You don't get compensated for your lost wages or the efforts that you spend preparing for court. So you do have to think about, are these fights worth it? And again, there are some other uh, just practical costs that Reagan will talk about a bit more in her section.
All right, and we are here for a quick Q&A break. So we've got two Q&A breaks scheduled for this presentation, one right here and then one at the very end. So if you don't get your question now or you have one later, don't feel like you're gonna get left behind here. Samuel, before we get to the first question, one thing I was thinking of when you were talking about the rent escrow affidavit, would it be helpful if sort of while you're answering these questions, if I pull up like the PDF so we can sort of walk through it as like a visual aid?
Yeah, and I can pull it up as well.
Okay.
So I can't share it, of
Okay.
course, but I can have it
Yeah.
in front of me.
Yeah, I can share on my end while you're answering. All right, so first question here. So how do you make sure that your rent escrow is sent to the right person, such as LLC, and like property managers versus the actual owner?
Sure. This is a great question again, because it is one of the things that you really do want to get right. The court needs jurisdiction. It, normally the answer is going to be fairly obvious because it's going to be written into the lease. That's the short answer. Well, I shouldn't say the short answer. That's the first step, is you would look at the lease and see who's listed in the lease. Who is the contract actually between? That's generally a safe bet. However, there are a couple other things you can do. Number one, depending upon where it is located, there might have to be a rental license, or there might be information online. So for example, Minneapolis has a bunch of records that are pretty easy to search, and you can see those online. And you can look up who the owner is. You can look up who the registered like rental license person is. Like, again, if they're an individual, probably not the right person, but gives you additional information. And then to get addresses, you can also do things like use the Minnesota Secretary of State's website to look up business information, to look up the registered address, the registered agent of a corporation or an LLC or any business like that. So sometimes you have to do a little bit of extra digging. But first step, look at the lease. Second step, think about, I shouldn't say think, like look at the names of the people that you deal with. Is there a business name? Look them up on the Minnesota Secretary of State's website. You can look up things, again, property tax records. The city might have information available, something like that.
Can we also pull on that a little bit more there? Because
Sure.
there are situations in which, as a property manager, that's different than the owner. Is there a benefit to uh, filing against one versus the other? Both?
Yeah, so you can file against the landlord. Landlord is defined as anyone who owns or manages rental property, which is pretty broad. So you can file against both. Now, to answer the question of whether or not you should file against both, some of that is just a practical or strategical choice about who you think will be most effective in solving the problem and what you think will apply the most pressure. So sometimes, if it's easy to get the information on both people or both entities, filing against both applies additional pressure, because maybe the owner doesn't want to be involved, right? Like, the owner has hired a management company for a reason, and all of a sudden being brought into a court case applies a bunch of pressure on a person who did not want to be involved. That's why they had a management company. So that can be nice, but it can also make things difficult, because you do have to serve people sometimes, again, especially if you go over that $20,000 limit. If they're a business, they've got to have a Minnesota address, which makes serving a lot easier. If they're an owner and they live out of state, then all of a sudden you do have additional rules. I don't even know those off the top of my head for how you would serve that person when they're not in the state. So there can be complications sometimes where maybe it's just not worth adding the owner, especially if they are not involved. You should almost always sue the management company. It's very rare when you wouldn't want to do that because the management company is managing the property most cases, and they're the ones who actually have sort of the knowledge and know-how to fix most problems. So you are almost always going to be suing the management company, and then you might want to sue the owner as well if either they're the same entity or the owner is involved, or you just think you can apply additional pressure.
All right, so I've got two documents or two websites pulled up here. The first is the Rent Escrow affidavit, which I will drop the link into for the chat. There we go. And then the Minnesota Secretary of Search. That's just like an example. So I'd search for Hy-Vee, just give a nice neutral example here. And they've got a bunch of subsidiaries, but we'll just go with their general, grocery stores. So you click through and you can find, mailing address, principal place of business, which is really what you're looking for if you need to serve them. And then sometimes they will have a registered agent as well. All right, so that's a good way to look that up. And then here we have the Rent Escrow affidavit form. Same if you want to just kind of walk us through this real quick.
Yeah, so at the top you have the basic sort of court information, the plaintiff, defendant. You have who the tenant is. Again, rent escrows are always filed by the tenant, and the attorney can obviously file on behalf of a tenant, but it is always the tenant who files. Then you have the name and address for the owner, the name and address for the managers of the property. If they're different, if there's only one, you could just list one. This is one thing where if you're using the smart PDF auto-populates the defendant as the owner, which doesn't need to be the case. And so sometimes it is easier to just get the straight PDF and use, some process like Edge or something like that, Internet Explorer, to type directly onto the PDF rather than using the smart PDF. Because again, the defendant should technically be both the owner and the manager, and the smart PDF tries to make it just the owner. But you got those two people. 4 is the list of problems. That's on the start of the next page. Again, this is where I see people mess up the most, where they write really long and complicated things, and it should just be a bullet point. Frankly, you might want a little bit more than this, but it can be mold, leaking sink, broken window, inspector's report. It can be all of those words just with commas after them, and that's preferable to like a 10-paragraph essay about the history of what's been going on. Probably the correct answer is somewhere in the middle ground, maybe just a couple words for each issue. Estimated cost of repairs, I talked about that. 6 is how you told the landlord. Again, that covers the two things, whether it's an inspector's order or the written repair request. A note on this, this form was drafted years ago. The court is definitely going to accept emailed notices. They will generally accept text notices now as well, especially if the landlord is replying to them. To be on the very safe side, we generally tell tenants still to either mail, hand deliver, or email the written notice, or use the landlord's online portal system. One thing to know with the landlord's online portal system is that landlords have control of this, and a lot of landlords have the ability to make repair requests disappear. Sometimes not maliciously, sometimes the system is just set up that when you mark a repair request as complete, it goes away. And of course, the tenant may not agree that it's complete, or the landlord may just delete it. So if the tenant is asking for repairs through the online portal system, they really should screenshot that or make some note of it.
Can I interject there?
Yep, go ahead.
Quickly. I'll also state all of those things are amazing. And I noticed some questions about evidence. Homeline does have a 14-day letter on our website that is available for download. And I will say, in my experience, the legalese involved in it, stating actual statute in it, is oftentimes is very helpful in showing your landlord that you mean business. and also allows you the ability to make copies in an easy way so that you actually have them on hand for yourself. So I just want to plug that in addition to all of the things that Samuel said.
Note that the court form says, I have attached a copy of the list of repairs. This is not technically a requirement of the statute, but I think tenants should be doing this. There's really no reason not to, and it is helpful to the court, and it shows the court that, you know, there actually was this written repair request made. It answers a question that then doesn't have to be answered later. So it's not technically required under the statute, but tenants should follow it. 7 is just about the rent, whether or not it's paid, and if it's not paid, that they're going to deposit it. And then 8 is where the tenant can say what things that they want. Tenants, tenants love to check, have an administrator take over. Tenants, landlords, or attorneys representing tenants, probably you should not check this. In all of my years of doing rent escrows, I can remember 1, maybe 2 cases where this has happened. This is a major hassle. It is only going to happen where there are repair issues that are so serious that have to be done, and the landlord has shown a complete inability or just outright refusal to do the repairs. And at that point, maybe the court will get involved and allow and order an administration. But this is a major headache. The court is not going to do it except in very sort of extreme cases. So I generally, you shouldn't even check this if you're a tenant or representing a tenant. And then other, that's the box, like I said, where the tenant should be writing down the things that they really want if it's not in this list. And especially as the rent escrow statute got broadened recently, I think you're going to see more and more of those, because the boxes that the court includes by default really are focused on repairs. All right, next question. What kind of evidence would we need to successfully file and win a rent escrow? Well, to file a rent escrow, you don't really need evidence. You just need the procedural letter or city inspector's report. But to win the rent escrow, it does, of course, depend on the issue. But generally, you need solid evidence that shows clearly that there's a problem. Most repairs you can photograph. Those are the easiest ones to win. The city inspector's report, like I said, also very good evidence. For things that are beyond basic repairs, like, you know, issues with the neighbor, noise, you need good recordings. Like if I were talking to a tenant and they said, I want to file a rent escrow about a noisy neighbor, the first thing I ask them to do is to send me a recording of the noise, because if they don't have good recordings, how are they going to prove it in court? Maybe they can get by on testimony alone, but in our experience, that's not enough. They need solid recordings. So it depends on each issue. And so it's hard to answer that generally, but you need stuff that the court will clearly see there's a problem. I think that answers the next one as well, except for I see the retaliation. But I think for the retaliation, I'll leave that for Reagan.
Yeah, I'll be touching base on that in my coming up. So we will get to that, Cassandra. Thank you for asking.
All right. When fighting a charge that was put on your ledger or repaired to your apartment that was not your fault, are there additional steps or different steps in filing something like that? So this is one of the interesting ones. Prior to this year, you could not have filed a rent escrow, or at least it would have been very difficult to file a rent escrow to dispute a fee. Now, I think you can do it because what counted as a violation was brought in to be all of Chapter 504B.001, and I think you can make a pretty good argument that charging a fee for an issue that the tenant didn't cause, like saying I'm going to bill the tenant for this repair, is a violation of 504B.161, which then gets you into a rent escrow. And that would be an interesting case, which I have not seen yet. There probably someone is out there working on it, I'm sure. And I'm sure people have tried them before as well. But now you could arguably do it in isolation. And Again, I just haven't seen that case. The process is basically the same, though. You would ask the landlord first to remove the fee in writing. You can't do it by a city inspector's report, of course, because there's no code violation. So the first thing you would do is ask the landlord to remove the fee. You would then wait 2 weeks. If the landlord doesn't remove the fee in 2 weeks, you would file the rent escrow. You'd go through the affidavit exactly as we discussed. The list of the problems or violations would be landlord is charging a fee in violation of 504B.161 and won't remove it. Again, that would be, maybe a little bit shorter, but just something that brief. The cost of the repair problem, at that point would be zero. You could put the cost of the fee, I guess, as well if you wanted. Everything else would be pretty self-explanatory. And then for 8, where you're asking the court to order, what you want the court to do, you would definitely want to check other, and you would want to say, remove the fee from my record. And then you could get in front of a judge. The one thing that I would have a concern about doing it right now is I think tenants, especially since the law change is so recent, need to be prepared with sort of an argument for why it's okay to do it. Because I think a lot of judges, especially if they have any familiarity with how rent escrows have worked in the past, will probably say, hey, why this isn't what you file a rent escrow for. This isn't a repair. Why are you doing this? This isn't the appropriate place to bring this argument. And so you've got to have your argument lined up to make that to a court.
All right, next question. So tenants filled out the exact template letter 2 or 3 times, and the management just ignored them. What should they do about that?
If you've sent the letter, and again, it sounds like this might be a person with an actual issue, probably it would be best for you to call our office and talk with us. But in general, if a tenant sends a letter and the landlord is not responding, they can wait if they want to, or they can just go file the rent escrow. Again, it really is, you send the letter, you file the rent escrow after 14 days. It's very, very easy to meet the procedural bar to get in front of a judge. Now, sometimes for various reasons, you may want to give more time. There's no point in filing a rent escrow if the landlord's going to fix it on day 15. Like, just give the landlord one more day in most cases. But that would be the normal process. Is if you've given the letter and it's been 2 weeks, you file the rent escrow. And again, if that was a question about an actual thing that's going on, I think it would be best if you're a tenant at least to call our office and talk with one of us directly, so we can ask real questions about the facts of your situation.
Mm-hmm. And I'll throw on that as well. And Samuel, please correct me and stop me if I'm veering off. But I have filed, and I'll get into this a little bit more, but I have been a part of a rent escrow process myself. I have sued my landlord in the past over repair issues, and we were able to bring forward as evidence that we had recorded the previous year issues that were still problems currently. So we were able to kind of take our 14-day letter that we had filed in 2021 and in 2022 bring that forward and say, we have filed this multiple times. There is evidence showing that we have done that. Here is our copies of this. And that definitely helped our case. It's not like that expires.
Yeah, that's a good point. Procedurally, you only need to send one letter, but from an evidentiary standpoint, the fact that you have been asking for repairs for months, or in some cases years, you can use those letters as evidence of that, and that is helpful in convincing the judge that there's a real problem that needs to be taken care of.
But for now, I'm going to launch into my monologue here. Hi, everybody. My name is Reagan Reek. I am Homeline's managing organizer. And as I just alluded to, I myself have gone through this process. And I have actually helped a number of tenants also go through this process in a group setting. So as an organized system. So let's get started into my perspective on this, because I am not an attorney. So I do have a different experience and a different approach about how I talk about this and why I talk about this with folks. So I think, first of all, it's really important for me to address and to discuss that there is a massive imbalance in power when it relates to tenant and landlord. Simply to say, housing is a necessity. There are tenant rights that are built into that. And from a tenant's perspective, this is an absolute thing that I have to have. So risk assessment coming from that angle is different than what your landlord's risk assessment is, which is coming at it from primarily a monetary perspective and looking at this as a business and as a way to bring in income. So their risk assessment is more about how do I maintain my property as cheaply as possible, while also fulfilling my right or my responsibilities, which oftentimes doesn't always happen and results in tenants having to move forward in filing escrow cases. So that's the main thing that we're looking at, and what rent escrows also try to help correct in this, because there is such an imbalance, and because a necessity is on the line for one party, bringing in a third party, they call them referees in housing court, literally to like ref what's going on, to look over this helps balance those power dynamics and those imbalances that we're looking at there. Organizing broadly, when I say that I'm an organizer, people kind of give me a funny look because they don't always know what that means. But generally what that means is I am not dealing necessarily with folks individually. I am dealing with people collectively. So I'm going into buildings where we are looking at the entire building on a broad scale. And there are individuals within that building, and everybody's experience is different, but where do those things align? So if we're looking at mass repair issues, if we are looking at mass violations of privacy, rent increases, things like that, we look at those systemic issues and try to come together collectively to solve those by working together. We can go on to the next slide. So why do group escrows? This is a practice I have done a few times. It is not my favorite thing to do because it is complicated, and we'll get into why, like some of the downsides of it versus the upsides of escrow. So I will say that first and foremost, like I know that there are a lot of barriers to this, and Cassandra had mentioned it related to like fears of retaliation. And I really will, I promise I'll dig into that in a little bit. But fundamentally, like, why do I look at this strategically as like a tactic that tenants can use together to find and to fight for their rights and fight for like correction of like what they need to be in habitable, safe housing, is because there's a lot of power in it. There really is. When you're doing it as a group, if we remember that we as renters are the ones that are actually paying the mortgage on the buildings that we live in, when we withhold our rent from folks once a month for a month, for 2 months, for 3 months, that does have an accumulated effect. And one person doing it may have an effect, and or they'll just, you know, your landlord could say that that's just cost of business. But you and your neighbors, 12 of your neighbors doing that, that is not just cost of business. That's actually a huge liability. So I look at it from that point. How can we leverage what power we do have in this situation, which is that us paying their rent allows them to pay their mortgage and keep their property and continue on in business. That's a point that I really like to hit home for folks when we're looking at like multiple people having issues in a building. Again, shared issues. This is also a very common refrain in my work that if you are organizing, when organizing is like, if you have an issue, it is really likely that your neighbor also has that issue, particularly if you're living in multifamily housing where you have multiple neighbors. So if you are a person whose stove isn't working, it's very likely that your neighbor's stove hasn't been working. Or if you have had multiple instances of your landlord coming in without notice or without proper notice and invading your personal space in a way that is not correct, it is very likely that is a common practice. So working together, talking together, there can be a lot of shame around some of these issues. I think that I also want to address there can be a lot of shame in this, saying, oh, this is my fault. And it can be said to us in that way by property management, when in reality, this isn't our fault. And if we were able to talk to our neighbors and discuss what is going on, it is very likely that we're all in the same boat and it's nothing that we did to cause this, but is the result of our landlords not doing their due diligence and upholding their responsibilities. Another huge piece is why I talk about rent escrows as being important, is because there is a legal safeguarding to the process in how you withhold your rent. So Samuel had brought up that it is legal to withhold your rent without going through a process in Minnesota, but it's something that Homeline very often does not recommend, and that I do not necessarily recommend. You look at, it's been coming up a lot in the news lately locally that mass rent strikes are happening across the nation and also here in Minnesota. And while that is a very valid and like strategic, intensely pressurized tactic to use in organizing, that is not something in my position at Homeline, which is technically a law firm, would ever advise to do, because of the risk involved in that. My fundamental position here is to make sure that people remain housed, that they do not have an eviction on their record at the end of whatever work that it is that we are doing, and that we're able to assert your rights and get you back into housing that is, get your housing back into the right order. So moving your rent into escrow, putting it into the court, offers a layer of protection that builds you up and protects you from a lot of the things that we've been, a lot of those fears that we're talking about here, that sort of legal protection can do that. It's also just very supportive in a retaliation defense. So there are some new laws that have come into place around organizing, tenant organizing broadly, that when you move through an official process and you can show, you say, I'm moving through this rent escrow process, I'm doing it by the book in the way that I'm supposed to, here is the result. And then months afterwards are having retaliatory actions against you because you asserted your rights. Having that on the books to show when you're coming up, when you're like wanting to pursue other actions, or your landlord is pursuing something like an eviction action against you, is a really strong indicator. And is a really hard thing for your landlord to refute sometimes. So I hope that kind of makes sense, because it's hard to like explain the timeline of what can happen here. But for example, you file an escrow, that's on record that you have done that. That'll be, I filed an escrow in Hennepin County. I went forward to housing court. They've seen me, they have seen this stuff. And then 3 months later, or 2 months later, I get a non-renewal of lease, or I have an eviction filed against me, whatever it may be, and I feel that is retaliatory. It is a lot stronger for me to say, I believe this is retaliatory because 2 months ago, I said, look at all these repairs that they haven't done. And the outcome of that was that, the outcome of my escrow case was that they didn't get the last 3 months of rent that I paid into court. So I believe that this eviction or this non-renewal is actually retaliatory in nature, and doesn't actually reflect my standing with my landlord. So that's what I'll say about that, about why I recommend that, as opposed to other like methods of like withholding rent. And we can go on to the next slide. So like other upsides of this is that it's one of the very few ways to proactively go after your landlord and enforce your rights as a tenant. I very often tell people in this case, it is a hammer. And oftentimes we need things that are not just a hammer. Sometimes we need a saw or a screwdriver. But what we're kind of left with is a hammer. And it's not perfect. It truly isn't. But it is one of those ways where you are not left on your back foot. You are not on the defense, but rather you are on the offense, asserting, I am doing everything that I am supposed to be doing as a tenant here. I have given notice about maintenance issues. I have followed up with my understanding of what my rights are, and those are being violated. Escrow actually allows you to go forward and say that, rather than having to try and defend yourself in that position. You're putting your landlord in the position of having to defend themselves. It is very fast, quote unquote, for a court case. In my case, we were in court for about 3 months to get this dealt with, which was a very long time to get things resolved once we actually got the process going. Generally, it is simple for a court case. I will say this is a lot of the language that attorneys I will hear use this, because from their perspective with other legal proceedings, it is simple. The caveat to that is that is for that is coming from people who are working within systems that have been built up for generations, to be complex, be arduous, be very precise and picky. I was listening to somebody talk yesterday about when you're looking at the law, and it was like may, should, will in a single word, changing the complete definition of something. So very like small, tiny details. Escrow has simplified it as much as it can. That being said, it is still not easy. And I want to really acknowledge that in this. Another upside is that tenants almost always win, usually, even when they're unrepresented against an attorney. If you have gotten to the point of filing an escrow where you have all of the evidence and you have all of that backing, it is very likely that there is something very wrong here. As I said earlier, like, housing as a human right, tenants sitting there weighing the risks of, do I keep living in a house that looks like this? Do I continue to let these repairs go unnoticed? Do I keep allowing, in my case, we had a bat come in every summer. We had stairs that were unsafe. We had issues with our plumbing. We had issues with electricity and with shortages and stuff. Where we had just gotten to a point where it was like, yes, we might be risking our housing here, but we have reached a point that we cannot keep paying rent for a place that is not upholding our basic needs as renters. So oftentimes we get to that point, tenants do win because you've stacked up enough evidence to say, these are the continuing issues that we have had for years, for months, for weeks, whatever it may be. We can go to the next slide here. And so some of the downsides when we're looking at these things is that, like I said, court can be difficult to navigate. I am a white woman with a college background, and my first language is English. And I was still sitting with the upset the night before and leading up to filing my own case that maybe I'm not doing the right thing. Maybe I am dealing with that. Maybe maybe I can deal with this and it's not as big of a deal as I'm making it out to be. Maybe I'm going to have to, maybe I've gone through all of this work for nothing here. So I really want to acknowledge that. And it can be doubly so difficult if you have any other things. I was also working a job at the time that was flexible enough that allowed me to take off the time to do so, to go to court in the middle of the day. So I really want to acknowledge that, as well as you need to have the money to be current on your rent. So if you've gotten behind on your rent for whatever reason it may be, and there are 1,000 justified reasons as to why that happens, this process does require you to actually have the money in hand for things. It can also take time for your issue to actually be fixed. Like I said, we were in court for about 3 months. And at that time, it was very frustrating how long it was taking just through the actual process. But as I've been able to look back on it, we dealt with some of the issues that we filed for over a year before we were actually able to get them solved. So it can take time. They can allow leeway. But usually at that point, you have already also been given, you have another person in your corner, that if the ruling is in your favor, you do have another person in your corner. You have the court system in your corner saying, no, you do need to enforce this. Also, it's a time commitment. So you're not just looking at the trial time, you are also looking at all of the time before that in communication with your landlord, filing your 14-day notices, preparing your evidence, getting a PowerPoint put together of all of the issues that you've had, talking to inspectors, all of these things. It really does build up. So that can be a huge downside to this. And the last one, and probably the most important one, and I've touched base on this a lot, so broken record time, but the fear of retaliation is very real in this process. And that is always a risk. I will say, anytime you are making a proactive move against your landlord is a risk to your housing. And it really comes down to personal decision there and personal risk assessment for your living situation. It may be worth it, that risk. It may really, really be worth that risk. For some folks, it may not be worth that risk, even if they're living in some of the most desperate types of conditions. I have worked in buildings where ceilings were literally falling in, and I could not get tenants to push forward on it because they really truly understood that in their situation, it was better to live with, their home falling apart on top of them than it was to risk not having access to, a place that had a door, a place that had lights, a place that had a refrigerator. So it really does depend on your personal risk assessment. And that's a lot of like what my job is also, is like, personally, everybody has a different assessment of risk. But when we're working in a group, that also gets alleviated a little bit. It's a lot easier to stand up as a group of 15 together and say, we're done dealing with this. You aren't going to evict every single one of us. You aren't going to retaliate against every single one of us because there's only 20 units in the building. So there goes 3/4 of your revenue stream all at once, if you're really taking us on in that way. And I think that's important to, that's important for me to talk about when we're looking at that in a large shared space. And I do really recommend that. Like if you are living in a multifamily complex where you are dealing with this issue and you're like, this can't just be me, go talk to your neighbors, go see what's going on. It may, there's a lot more power in your numbers together than there is alone. And I don't want to end on the downsides. We're about to move to questions, so I'm going to give y'all some time to think about your questions. But before I deeply dive into that, because I don't want to end on a downside of why you shouldn't do this, is like, we've had a lot of really positive experiences from this. For my own personal experience, we did wind up settling. But the settlement was that we got a month's rent back and we got out of our lease early. We also had the other terms of the court order violated by the landlord towards the end of the session. And so we wound up getting the entirety of our security deposit back. So we came out with all of us having a month's worth of rent back to us, as well as being able to leave the property early. With other buildings that we have worked in, we have seen things that they have dealt with for months and months, where a 14-day letter was sent in multiple times by people, and they're dealing with things like smoke damage on windows, stoves not working, ADA push buttons not being functioning. But the fact that they went through and they did push and they said as a group, this isn't acceptable for me and it's not acceptable for the rest of my neighbors. We had a number of folks that did that on behalf of their neighbors for common spaces that improve the quality of living for everybody in the building. We also recently had it by, like I said, sometimes just filing the 14-day letter is enough to spurn people into action about stuff. An elevator that had been down for weeks at one of the apartments we had been in, that management kept just pushing off because there was another one that was available for them to use, but wasn't accessible to half of the building. Once they filed the 14-day letter saying, we are going to take you to court if you do not fix this, the parts magically had come in within 24 hours to get it repaired. So there are serious benefits to this. I have seen people get, I was recently told about somebody who got almost 2 years worth of rent back because of lack of heat, that they had gone through this process. They didn't know that they had rights in this way and had been living with poor heating issues for 2 years and had gotten most of that back by the time they had gone through this process because of the evidence. So it's arduous, it's exhausting, and it is not for everybody. But if you have some tenacity and a little bit of grit, like, it really can turn into something that benefits not just you, but your neighbors as well.
And Reagan, perhaps I missed this, but did you talk about what you mean when you say collective rent escrow?
Yes, a little bit. I can dive into that a little bit more. So when I say, go ahead, Samuel.
I was just going to say that I think you're going to say it first, so I'll let you go, and then if there's anything else I want to add, I'll cover that.
Yeah, because to clarify, I am not an attorney. I already said this, but I use terms in a little bit less, in a more of a loose manner sometimes. But when I'm talking about a collective rent escrow, I'm talking about everybody individually filing escrows at the same time. So it's me, Philip, and Samuel and 6 of our other neighbors saying, all right, on the 1st of December, we filed our thing, 5 days ago, mid-November, we filed our 14-day letter report. And so by the 1st of December, we are going to go in on court same day, and we're going to file all together. That's what I mean when I say collective rent escrow.
And I think just from the legal perspective, the thing to know is that you can only a residential tenant can file a rent escrow, and they can only file individually for themselves. So there's no way for separate units, like units, 1, 2, and 3 of a building, to file a single court case. Roommates or multiple tenants on the same lease can definitely file a single rent escrow. But if there are 3 or 4 units, they all have to file separately. There is a way to file a collective action under a tenant remedies action. But you have to form a neighborhood association, and you have to be represented by an attorney, and that's not really possible for most people. So what Reagan is talking about is sort of the rent escrow version of that, and it does really work. And again, as Reagan explained, every tenant goes and files on the same day, preferably at the exact same time. And even though they will be entirely separate court cases, when a judge sees that, first of all, just due to how it's done, they'll probably all be assigned to the same judge on the same calendar at the same time. So the judge will hear, it will be the same judge hearing all of them. And even though they are, again, separate court cases, it makes it easier to coordinate witnesses. It makes it easier to coordinate the tenants showing up together. It makes it easier for tenants to support each other in the separate cases. And it does have a real impact on the judge, who is now seeing 3, 5, maybe even more of these cases against the same landlord. And you get the full picture of what's going on. It is more work to coordinate. It is certainly not required, but when it can be pulled off, I mean, it has a lot of additional pressure on the landlord, as Reagan mentioned.
Yeah, it's just a lot more intimidating probably to have to, landlord might not be feeling so intimidated to go in against one tenant, but they definitely do feel the pressure when it's 3, 5, 10, 15 people all at once. That's a lot of work for them, and it is really not a good look. If you have that many folks coming forward saying, hey, we have, because you can file escrow for common area issues. So like you can file for them within your individual unit as well as in common areas. So for 15 people to come forward and say, we have all of these individual issues in our own units that we have not had resolved, and they may or not be the same across the board. But in addition, saying all of us also have these serious issues with the common area and how it's maintained and what it looks like. That, as Samuel was saying, puts a lot of, allows for a better perspective for the referee and what's going on there.
All right, so we got a few questions here in the chat. First one, Samuel, I'm going to direct to you. Does Homeline offer representation in rent escrow cases? If not, what limited services do you provide?
The short answer is no. Homeline only provides free legal advice to residential tenants, either by phone or email. Very, very rarely we do direct representation in a court case. It's like 1 a year, and we talk to around 20,000 tenants. So it is not common. It is never something we would promise. And just in general, our policy is no. That said, there are a couple things we help with. If you send us, you've got to ask for this in some cases. Sometimes we'll offer it, but if you actually fill out the rent escrow affidavit and send it to us before you file it, we can generally review that for you and make sure that it looks correct. Again, when I talk about, tenants, putting too many things in or not asking for what they want, part of the way I know this is I've looked over a lot of rent escrows that tenants have filed. We can talk with you about various questions. We can't walk you through 100% of what it's like to prepare for a rent escrow, especially since so much of it is sort of at the judge's control that certain things can be hard to predict. But we can talk you through sort of the basics of what to expect. We can talk you through the basics of how to prepare your evidence. You still have to prepare it yourself, but oftentimes what I will do if I am working with the tenant who's filed a rent escrow is I will have them write out their testimony, and then I will, review it and make sure that they have said, like, hit the points that they need to hit in their testimony, that they're correctly referring to their evidence or so on. And so there are certain things that we can do in sort of the background, for lack of a better word. And also prior to filing, we can do things like review your evidence. I do this a lot where I look at the evidence and I say, okay, this is or is not good enough in my opinion, and it is important to understand that it's my opinion. Judges are not me. I am actually probably more biased in favor of tenants than most judges because this is my job, which means a judge may have a higher standard than I use, but they may also have a lower one. This comes up a lot with like repairs. Is let's say the heat is 64 degrees. For some people that's very cold, and there are other people who just set their house to 64 degrees all winter, and you don't know which judge you're going to be in front of. If you are a tenant like bringing a claim for low heat. Now, fortunately, with heat now, this changed recently. There's now just the standard of 68 degrees. So that got a lot easier. But prior to that law, you just didn't know what your judge would think. And you have that with other issues. Like, let's say you see one mouse. Is a judge going to care about that? There are some judges who would really care about even a single mouse. And I think there are some judges who might say, one mouse, not that big of a problem. We're not going to do anything for it. And so that's something to understand, is that the judges have a lot of control. But that's sort of what we'll do. We can walk you through the process. We can look at certain documents. We can't draft them for you, but we can review them for you. In most cases, we can give you some general advice about the types of evidence that you have or need, and sort of how you prepare for the court hearing.
And I'm gonna jump in here quick. Samuel is actually the attorney that walked me and my roommates through our escrow filing. And I will just like personally speak to the fact that it was incredibly helpful. We aren't able to do everything at Homeline because we do not represent folks. Mostly we don't. But the advice that was available and like given to me was incredibly practical, was very helpful, and generally just like helped get rid of like a lot of the idea of like, this is not a space that I can enter into. I also want to highlight that your court clerk, so that would be available on this process, on the paperwork that you file if you get to that point, is also going to be one of the most helpful people in this process as well, when you're actually talking about like the procedure and the processes at court. So those are kind of two separate windows there that I want to highlight there of, yeah, call your court clerk. They want to talk to you. They're very helpful, in my experience. Along the same line, how can organizers best assist tenants with the rent escrow process? There's a couple different things that my team is able to do. I'm going to put this out there as a huge caveat that there are 2 of us full-time who serve the entire state. So it is incredibly dependent on our capacity about what we are able to help with. But previously in the past, when we've been working with the building for a while and we've gotten to the point where they are willing to file a collective escrow together, I've been able to set up sessions in which on one day I was able to bring in an attorney who had capacity from Homeline. We all went through and we all filled out 12 of the affidavits together. So we all did that in one process. I was able to support being there in person, just as moral support. I am not an attorney, so I cannot give you legal advice while we are there. I cannot be in the room with you, but I was able to be there in that sense of like, here's a familiar face who is familiar with this place. We don't have to worry about this so much. So there's some things that that the organizers are willing to offer on a case-by-case basis. And I'm also saying, like, very much case by case. It's very dependent on our capacity and our relationship also. My work is very relational. I work with people for years at a time. And yeah, if I know you and if we've been able to establish that, and I've gotten to a point where I'm like, yep, we're absolutely going to get to this point and we're moving forward towards that, and I can trust that we are going to move towards that, then that is a valuable like use of my time, I believe, and of my time, of my team's time. But yeah, I just don't want anybody to take offense if they reach out and they said, you said you'd be able to help us with that. It's really dependent on our capacity. So let's put that out there.
All right, looks like last question here. Does filing rent escrow hurt my chance for renting somewhere else? I think they're talking about in terms of like rental
Yeah.
referrals.
So the short answer is, I mean, it's the short answer is the legal answer of maybe. There are a couple things I can say with more specificity. First, tenant screening companies don't report it, or at least I'm not aware of any tenant screening company that does. So it's not going to show up, at least, again, I'm not aware of it showing up on like a tenant screening report. So if you pay a landlord an application fee, and you get a tenant screening report, it's probably not going to show up there. However, it is public information. Court information is public information. So a landlord could, in theory, search your name. And there are some landlords who do their own background checks, air quotes, by going onto the court's website and searching people's names. So it is possible someone could see it. And if they see it, that person could, in theory, use that as a reason not to rent you. Now, again, if landlords don't generally check this, it's not really part of application criteria. And under state law, if a landlord is going to charge an application fee, they have to have a written list of criteria. And I've never seen it in that written list. The final way, and the most likely way it would be a negative effect to someone, is if the landlord is one of those landlords who actually calls prior landlords. And this is, I think, becoming less and less common. But if you sue your current landlord, or you help a tenant because you're an attorney, sue a current landlord, and they go rent somewhere else, and that new landlord or prospective landlord actually calls the landlord that your client sued or that you sued, that landlord might give a direct negative reference or just say they sued me, which the prospective landlord may care about. Again, under state law, if they're charging an application fee and they want to use it as a reason, they have to have that in their list of written criteria, which I have never seen. And just anecdotally, I don't think we've ever had a call from a tenant saying, I was trying to apply at a place and I got denied because I filed a rent escrow. But I mean, the answer is it is public information. In theory, it could happen. It is not something we see happen.
I'll also pull on that. Like, I think that's a really fabulous question. In regards to like why we kind of back this process over other like legal means. Is that if you do get a point, oftentimes if you're withholding rent, you will get to a point where an eviction is filed against you. And so if we do get to that point, that is on your record and that is absolutely able to be seen. So even if the end result is that you're like, I do have the money, you can't be like evicting me over this and withholding it for rent. There is still that sticky piece of like an eviction was filed. It should be taken off your record. It should be expunged. But does that always happen? And the answer is no. We have seen that, like, I know I have seen that happen where it's like an eviction was filed, it was supposed to be expunged, and it was a whole other process and mess to get it expunged after the fact.
Yeah, as Reagan said, one of the primary reasons that we as Homeline recommend rent escrows over withholding rent, even though withholding rent is technically legal, is because if a tenant withholds their rent, what the landlord does is files an eviction. And that goes on a tenant's record. If the tenant loses for any reason, even just like not showing up at court, their transportation breaks down, it's by Zoom, their internet doesn't work, or they try to present evidence and their evidence doesn't get in for one reason or another. If they lose for any reason, they lose their housing. And even if they win, that eviction goes on their record. And as Reagan said, the tenant has a good argument for getting it removed, but they've got to go through that process. Tenant screening companies may have already collected that information. Sometimes it shows up in reports even after getting expunged, which means you've got to go talk to the tenant screening company. And the other primary reason we say rent escrows over eviction or over withholding rent is because in an eviction, all the tenant can really win is not getting evicted and maybe rent abatement. depending upon how it's done. Whereas in a rent escrow, they can get repairs, they can get rent abated, they can get all of these other things. So this, to go back to the question of does this affect your chances? The answer, again, probably no, maybe yes, but in some cases you have to think about, what the other options are. And this is true for retaliation too, unfortunately, but if the repair issue is serious and it's something you care about, rent escrows still are the best way to go. They're not perfect. There are downsides, but they can, in many cases, get the tenant what they're looking for, at least more of what they're looking for than any other option that's really available to tenants.
One last note here, because we got a few questions in the chat about it. If you came in late, or if you just want to view this recording later, it will be available on our website, typically within a day or two. Just go to homelinemn.org. It's under the training tabs. I would probably check back Monday just to be safe, and you can find the recording then. And with that, we are right at 3:30, or yeah, right at 3:30 right now. So good job, everyone. Thank you for attending.